answer your first question.
Well, then I would certainly make that motion that we do agendize it, and hopefully in that meeting that you would return, and staff if need be, and give us some cogent arguments why or why not. I mean, I think that it's merited. I just think you can't release a part of a document and then characterize the whole totality of it that no one has seen. And I've not seen any of this because these mock jury sessions were superseded many of us who are seated up here on this council, and I have never seen that document until those slides were put up on that screen during that presentation. And so I think it certainly warrants a full discussion, and let us decide whether or not we want to or don't want to, but I think the argument needs to be made why or why not.
Okay, anybody else?
I'll second the motion.
I don't believe it. Can we get through announcements first?
There's the motion.
What is the motion?
The motion is that we agendize this be brought back at the next meeting.
Gentlemen,
I'd like to speak to it for a second.
go ahead.
I think it's fair to say, Mr. Duclos, I don't think any of us have seen it. I know I haven't as well, so it wasn't just something that superseded your time. Do we, either of the five of us, have the ability to read that document today, tomorrow, if I came to your office? Do I presently have the authority to read that?
Any one of you could read it if we had it. I don't have it. I've never had it.
So nobody gets squirrely about it. Who has it? And just explain that a little bit.
The law offices of Bird Morella,
Who was our
litigation counsel in the Macpherson litigation, commissioned the mock jury exercise for purposes of trial preparation. The product of that exercise is considered to be what's known as attorney work product. Basically, it is a classic exercise of what attorneys need to do in order to prepare a case for trial. It is confidential and it is privileged. The actual report that was prepared, I don't believe has ever been in possession of the city. There was a report made to the city council in closed session regarding that exercise by the attorneys at the time that the exercise was done, but I don't believe a report resides here in City Hall, and one does not exist in my files either. So, as a practical matter, we would have to obtain it from our attorneys, and it's our right to do so and make it available. The slides that were presented in the State of the City address were just a small portion of the full report.
But clearly they were in the possession of...
I am sort of constitutionally interested in doing this, but I am incredibly alarmed at having a public discussion about a private document that I've never read, and I have no idea how to process the other implications that document or other documents that are owned by our that reside or work product of our attorney have on our long-term issues. This is a quandary. I'd like to maybe propose a friendly adjustment to the friendly amendment that we agree to put an item on other matters at the next meeting that calls for the item to be agendized at the following meeting, and between now and then